Hi everyone, sorry for the delay. There were some last minute technical issues, but we seem to have sorted that out now. Thank you for joining us. Welcome to today's session on using the small business restructuring packages to reposition your business, particularly for recovery, although given the economic news, it's hardly to say it's a recovery, it's a massive bounce back. My name is Norman Donato and I'm a partner at Bardia Perry's corporate and commercial team. Joining me today will be Samantha Pacchiarotta from Bardia Perry and Ian Nicol and Andrew McAvoy from Aston Chase. I'd like to begin by acknowledging, however, and paying my respects to the Gadigal people of the Eora Nation, the traditional custodians of the land on which we are broadcasting from today. I would like to pay my respects to their elders, past, present and emerging, and acknowledge all Aboriginal and Torres Strait Islanders joining us today. Also paying my respects to your elders, past, present and emerging. Before we get started, I'd like to go over a few items so you know how to participate in today's event. You will have the opportunity to submit by text questions at any time during the webinar using the control panel, and I'll endeavour to answer them at the end of today's seminar. What we'll do is we're going to have a very sort of broad discussion after we outline how the new system works and some of the requirements. And as I said earlier, we're lucky today because with me, we've got Ian Nicol. Ian is a co-founder of Aston Chase Group with more than 15 years formal insolvency and restructuring experience. Ian advises and specialises in mid-market clients and stakeholders, previously working with Deloitte's restructuring team and leading restructuring and advisory firm. McGrath-Nichols and during this time, he supported a range of engagements across industries. Ian has significant experience providing independent advice to key stakeholders of underperforming and distressed businesses. This includes strategic and operational restructuring, security reviews, exit strategies, sales of business, and working on capital management. Similarly, Andrew has 10 years experience in the insolvency industry and has worked on some of Australia's largest corporate insolvency engagements. He was formerly with the leading restructuring and advisory firm McGrath-Nichols as well. He has developed experience in a range of formal and informal insolvency matters, including receiverships for major banks, investigations into the reasons for large-scale corporate collapses, and independent business reviews. And last but not least, we're also lucky to have Sam Pacchiarotta. Sam is a lawyer in our corporate and commercial team at Bardia Perry and has previously worked in the commercial disputes team at. Sam is also a qualified chartered accountant. Excuse me. With over 5 years experience in insolvency in the private sector and at the Commonwealth Agency, the Australian Financial Security Authority. She has experience working on a range of insolvency matters, including independent business reviews, voluntary administrations, liquidations and bankruptcy. Significantly, in 2018 and 2019, Samantha attended the Insolvency Working Group at the UN Commission on International Trade Law in Vienna. Her role was to report to stakeholders in Australia on the working group's work on a simplified insolvency regime for medium to small enterprises, and where she was able to witness the fascinating process of the harmonisation of international law. Samantha recently returned from the Netherlands, where she completed a Masters of Globalisation and Law. As part of her Master's research thesis, Samantha proposed a set of recommendations for reform to Australia's restructuring law based on international best practice. And so once we get to the practical discussion, I'm sure we're going to get a lot of insight from our panel speakers today. I thought I'd start by really setting out a bit of the background to today's discussion. And I guess there's going to be a theme, and the theme for any successful restructure is that people are able to not bury their head in the sand and actually look at the signs and move quickly, and then get the right support that is needed as quickly as possible. And the report, the background to the changes that came out were that that which came out of the insolvency inquiry report, which was handed down in 2020, and the forward by Kate Cannell, the Australian Small Business and Family Enterprise Ombudsman, I think summarises the problem. And I want to set out the problem, and so then when we get to the practical discussion, we can consider just how far the new measures go to dealing with the problem. Kate Cannell said in the forward to the report, following the completion of our inquiry into the banking sector's treatment of small businesses, we quickly identified a major issue in the insolvency process for the small business community. Often where small businesses are seeking support to turn around their business in response to financial pressures, they find themselves on an express train to winding up with no control over the process. For many, the liquidation process has been so traumatic that they will never fully recover, let alone try to start a new business in the future. Small business owners report facing an opaque system where decisions are taken out of their hands, they feel pushed into outcomes they were not looking for, and their expertise or knowledge of the business they have been running is discounted or ignored. Business owners talk of stock being sold at a low point in the market, assets being put up for sale in publications that are not particularly relevant to their industry, and thousands being spent by registered liquidators to chase down payments worth less than 1/10 of the amount spent. Unsecured creditors, most often small businesses themselves, see very little return from the insolvency process. But it's absolutely critical to our economy and communities that we continue to encourage entrepreneurial Australians to give their dream a go. In other words, we don't want them to quit, we want them to have a go. And some of the statistics I think are also important when we have a look at what's been happening in liquidations. And the report says that between July 2018 and June 2019, the companies entering into liquidation, 85% had assets of less than $100,000. 58% had less than $10,000, and almost 37% were reported as assetless. Only 8.5% of companies had assets over $250,000. Almost 76% had liabilities of less than $1 million. 38% had less than $250,000. 76% had less than 20 employees, and slightly over 81% had no outstanding employee wage entitlements. 92% estimated the return to unsecured creditors would be $0. These figures suggest that the current framework, or before the introduction of the new business regime restructuring, that in theory, that the focus to maximise returns to creditors is basically, or has been, a failure. And so these new reforms are designed to address some of these concerns and to give the opportunity for small businesses to come out, remain in control, and seek an effective restructuring process so as to hopefully be beneficial not just solely for creditors, but also for the debtor themselves, and to encourage people to have a go and have an ability, if they do find themselves into trouble, to try and turn the business around more successfully than has been the case in the past. Now, to be eligible to take advantage of the new provisions, it's called the small business restructuring, but in many respects, it really triggered on the amount of liability that the company has. And the first criteria is that total liabilities have to be less than $1 million. No person who is a director or has been a director within 12 months or has been a director has been in the process of restructuring in the last 7 years. the company has not already been through a process in the past 7 years, a similar process. And if you satisfy the eligibility criteria, then you're able effectively to remain in control of the process and prepare a plan and work through that plan. And we'll go through the consequences if the plan is entered into in terms of how it affects shareholders, creditors, office holders of the company. But the process effectively is a process, there's a number of stages. And the first stage is the restructuring stage. And that it starts when the restructuring practitioner is appointed. And effectively, the directors have to make a declaration to the effect that the company is insolvent or likely to become insolvent at some time in future, and appoint the restructuring practitioner. That commences the process, and once the process is commenced, the parties then work on preparing a plan. Now, there's certain requirements of the plan. It must be in an approved form. It's got to identify what property is subject to the plan, provide remuneration for the restructuring practitioner, and specify the date for the restructuring plan to be signed. Effectively, it's got to be prepared and executed within 20 business days of the commencement of the proposal period. There's standard terms for the plan that have to be incorporated, and any plan which is inconsistent with the standard terms will be deemed to be void. Those standard terms include all admissible debts have to rank equally. If the total amount paid is less than those debts and claims are to be paid proportionally. No creditor may receive in respect of their admissible debt more than the debt or the claim. The amount of admissible debt is to be determined as at the time immediately before the restructuring commenced, and secured creditors will only be a creditor to the extent that its claim is greater than the value of its security. And the legislation has a form of plan. The plan may also authorise the registered practitioner to deal with identified property. It may also provide for any matter relating to the affairs of the company, and there may be conditions precedent to the plan kicking in. But if there are, they need to be specified, and the date on which they are to be satisfied needs to also be set out, but that must be within 10 business days of the plan being accepted by creditors. What a plan cannot do is it cannot provide for the transfer of property other than money to a creditor, and the company property can only be used to cannot be used to make payments under the plan in respect of admissible claim more than 3 years after the restructuring plan is made. So the prerequisites for starting the process is, and for the directors to remain in control, is that the plan has to be executed. It's got to be signed by the company within the proposal period, as I mentioned earlier, 20 business days. The registered practitioner has to make a declaration that he believes or she believes on reasonable grounds that the company meets the eligibility criteria. If the plan is made, the company, and also that if the company is made, it is likely to be able to discharge the obligations created by the plan as and when due and payable. And all information for the restructuring proposal statement has been set out, or that such belief, and if such belief is not held, they have to specify the reasons why not. It's got to identify the creditors who will be party to the plan, the affected creditors, and the company must have or substantially have paid all employee entitlements and lodged all tax returns before it can get voted on. Now, the voting in relation to the plan is going to be based on a simple majority, and that is determined by the value of affected creditors who vote within the acceptance period, and that is a distinction And we can talk about that later when we compare in relation to VA. Where in a VA, you need both a majority in terms of value and number of claims admitted. Now, the plan can be terminated or it ends, the restructuring stage, when the directors decide to end it. If there's no plan proposed during that restructuring stage, the proposals lapse because the plan was not accepted. It could also lapse because the registered restructuring practitioner cancels the proposal, feels that there's been a change and it won't be achieved. Through a court order, or there's an administrator or liquidator appointed. Now, the important things, as we mentioned earlier, that if you get to the point where you enter into the restructuring stage and you put together a plan with the help of the restructuring practitioner, which is one of the functions of the restructuring practitioner to assist with the preparation of the plan. In fact, the restructuring practitioner's functions are to provide advice to the company on matters relating to the restructuring, to assist the company to prepare the restructuring plan, and to make a declaration to the creditors in accordance with the regulations, as I mentioned earlier, and any other functions given to the restructuring practitioner under the regulations. It's the duty of the directors of the company to assist, and in fact, unless they have a good reason, it's an offence not to assist the practicing the restructuring practitioner. But more importantly, let's look at the consequences of the restructuring. Now, the legislation, as we said, requires that there be a declaration that the company is insolvent or likely to be insolvent. So there's a presumption of insolvency. Now, that may or may not be a concern to some people who are trying to turn around the company, and it's a question of whether or not, that helps them come forward early enough and try to deal with the issues. In terms of contracts and ipso facto provisions, by entering into the restructuring stage, there's an automatic stay preventing counterparties from enforcing contractual rights triggered by the restructuring or the financial position of the company, but there's certain exceptions that allow that to happen. And it doesn't constitute a repudiation of any agreement. There's also a moratorium on any court proceedings which affect the assets of the company. Now, what are the consequences for the officers? Well, during the restructuring stage, the safe harbour provisions apply. Directors remain in control, subject to certain exceptions. And then after the implementation stage, the officers are bound by the restructuring plan, but still remain in control. But they are then subject to any insolvency trading prohibitions in the Corporations Act. For secured creditors, during the restructuring stage, there's a moratorium on enforcing their security. Application for the court order preventing secured assets from realising their security can be made. Effectively, the exception to the moratoriums is where the restructuring practitioner consents or a court order consents. The security held by the secured creditor is over the whole or substantially the whole of the assets and enforces within 13 business days of notification of the commencement of the restructuring. Enforcement has already commenced or there's security over perishable property. As I said earlier, the court order can be made not to realise security if the realisation would have a material adverse effect on achieving the plan, and it's in the interest of the secured creditor, otherwise adequately protected. Now, as Sam might talk about later, that's an important, I think, feature of the new legislation, the ability of the court to step in and for court orders to be made, which allows secured creditors to play ball in relation to the restructuring plan. And any unperfected security interest vests in the company during that stage. At the restructuring plan stage, there's no more moratorium. The court may still make orders not to realise security. The restructuring plan is binding on some of the secured creditors. So it's binding on secured creditors to the extent to which their security is insufficient to cover the debt or consent to the restructuring plan. And the restructuring practitioner cannot dispose of incumbent property subject to certain exceptions. And that is, for example, that if it is disposed, it's disposed in the ordinary course of business, the secured creditor consents, or there's relevant court orders in place. For owners and lessors, the consequences are there's a moratorium that applies during the restructuring stage, and again, they cannot, without the consent of the restructuring practitioner or the leave of the court, take any enforcement in relation to any premises or goods, even if they're under a PIMSI, and they can't enforce any security. They have no priority for rent payable during the restructuring phase. But during the restructuring plan stage, however, there's no moratorium. Property rights are unencumbered, subject to certain exceptions. And they are that, unless they voted in favour of the restructuring plan as well, as similar to secured creditors, or in relation to retention of title. The restructuring practitioner also has limited is limited in the ability to deal with third-party property unless the disposal again is in the ordinary course of business, the secured creditor consents, or the court grants leave to do so. For shareholders, what are the consequences? During the restructuring stage, they can't transfer shares or change the status unless with the consent of the restructuring practitioner or court order. And then during the restructuring plan stage, there's no stay on share transfers and other changes, but they're bound by the restructuring plan. Now, this next slide shows some advantages and disadvantages in comparison to some of the other restructuring options that companies have that meet some difficulty. I won't go through that in great detail because I think that'll be something that Ian and Andrew discuss when we look at some of the practical considerations. But of course, the intended major benefits are supposed to be the cost effectiveness of this process being a lot less formal and supposedly saving on costs, a simpler process, shorter time frames, and quite significantly the issue that the directors remain in control. What I might do now, whilst we're talking about comparisons, is hand over to Sam Pacarotta to tell us about some of her experience in the international level before we then get into a bit of a practical discussion and see whether or not this regime facilitates and brings together the criteria or deal with the impediments that stop people from addressing issues early enough for it to be successful. Sam, I might hand over to you.
Right, thanks, Norman. There has been quite a bit of activity and discussion in this sphere at the international level, but I'd like to focus on 3 key points which I consider of interest. The first point is that there has been growing support internationally for a debtor-focused approach to restructuring. The World Bank and UNCITRAL have advocated for quite some time for countries to adopt restructuring processes that focus on providing a fresh start to the entrepreneur that is in financial distress and encouraging an entrepreneur to address financial trouble at an early stage before the point beyond rescue. And there has been a shift. We've seen several jurisdictions implement a debtor-led, debtor-in-possession approach to restructuring, such as Singapore and more recently the Netherlands, and Myanmar. And of course, there is the US that is well known for its restructuring, debtor in possession, restructuring process under Chapter 11 of the Bankruptcy Code. In looking at what other jurisdictions are doing in this sphere, I think it is interesting to consider the restructuring frameworks that other countries are adopting. We can see that in some jurisdictions, the courts play a much more involved role. So, for example, in the US and in the Netherlands, the restructuring process is overseen by the courts. The debtors ultimately remain in control of the process. However, the courts are required to verify eligibility requirements of the debtor, to confirm a plan that has been approved by creditors, and it is not uncommon for the courts to approve that the debtor borrow further money, which is known as debtor in possession financing, and which acts as a cash injection into the business, stabilise the business and fund the restructure. I think it's also interesting that the reason why these frameworks in the US and the Netherlands work well to incorporate the courts is because that these jurisdictions have the judicial infrastructure to offer a court-managed, debtor-led restructuring process. In the US, the Americans have the bankruptcy court. In the Netherlands, the Dutch have the commercial courts, and these courts specialise in insolvency and commercial matters. Another interesting point when looking at what other restructuring processes are available is to consider how other countries tackle the issue of stigma that is associated with insolvency. There is a growing view that restructuring is more like a hospital and less like a prison. And UNCITRAL has said that in order to encourage entrepreneurs to access restructuring procedures at an early stage, countries should avoid adopting procedures that create the stigma of failure. And this can be seen in practice, where policymakers in some jurisdictions have carefully considered ways to alleviate stigma in drafting reforms. In the Netherlands, for example, the debtor has the flexibility to decide to include all their shareholders and creditors within a restructuring plan, or only to include those creditors and shareholders whose rights they're most likely to infringe. And this helps not only to reduce stigma, but also enables the business to preserve its crucial business relationships by maintaining an image of business as usual. So that's a very brief overview of what is happening at the international level. And Norman, I'm going to hand it back to you.
Thanks, Sam. So before I bring in Ian and Andrew, as we said earlier, I think a successful restructuring process requires a number of different ingredients. During my time as a commercial and finance lawyer, I've worked both in terms of putting together workout plans for secured creditors and some of their debtors, and also undertaking sort of some informal restructuring processes, and managing a lot of risks that are there for people who are trading on the verge of insolvency. But there's a number of important ingredients that go together in being able to turn around a business and to put a restructuring plan, whether under the new small business regime, before that, if the debtor is having problems with their financier, or through a VA process or one of the other processes. And briefly, I think some of the key ones, and we'll bring Andrew and Ian in shortly to tell us their views on this. It's important that there be adequate funding to see the business turn around and go through the process. Obviously, what's brought it to the brink of liquidation is some financial issues, and there's costs that need to be addressed during the restructuring stage. And so one of the things that I think we'll look at perhaps developing more in Australia and and it does happen overseas, is debtor in control lending. And we can talk about that a little bit later, but essentially there has to be some financial plan to see it through that stage. The successful turnarounds that I've been involved in, the businesses have had a good relationship, whether it's with their financiers or with some of their suppliers or customers, and have been able to deal with them in a way that the stigma has not caused them to either be reluctant to come forward or lost the trust of their customers or their suppliers. Obviously, there's got to be possibilities. I mean, sometimes you start a business, I suppose, and there's just some fundamental problems with it and it can't be saved. But oftentimes you see that with the help of people like Andrew and with Ian, they're able to locate ways of improving the management and the operations of the business. And if they get in there early enough, they're able to actually be effective and to turn it around, or hive off the bad parts of the business and focus on the good business. And then there's the control, having the adequate input of the owner of the business, the people who run it, understand it, know what supposedly drives it, and not make them feel, as was stated earlier, like they're on an express train to oblivion. But I think maybe at this point, it'd be best to hand over to both Ian and to Andrew to just have a discussion about what their views are on the changes, what they see some of the possibilities, what they see as key drivers and in terms of successfully turning around a business, whether informally through this process or through the VA, and give us their insights. As I said earlier, if you've got any questions in particular, now's a good time if you haven't already sent them through. But Ian, I might sort of hand over to you briefly to tell us your thoughts on the new regime.
Sure, thanks Norman. Just probably a good place to start is, what we're currently seeing right now, since the introduction of the small business regime. And typically what we're seeing is since the introduction of the regime, we're having a lot of discussions with directors and talking about the potential restructure of their business. But, we go through the whole process of an informal advisory matter or through the formal process, which you've just mentioned in this presentation. And what they tend to do is they tend to adopt a head, like you said right at the beginning, bury their head in the sand approach. And that may be because over the past year, respective governments have provided, and institutions have provided stimulus measures which have propped up the economy during the times of COVID. Obviously everyone knows about JobKeeper, rent waivers and deferrals, ATA deferrals payments, the supplement payments that were all of a sudden appear in your bank account from the ATA, which has been fantastic for SMEs. Cheap loans from banks, which are 50% secured by the federal government. So there are all these things that were helping out, which probably gives a director, well, I've made it this far, perhaps I can get out of this myself. And while that's the right attitude, they may not have the expertise or the skill set required to restructure the business. So directors, as of the end of JobKeeper, all these SMEs would have been finding out that the deferrals that were put off are now due and payable. So that list of stimulus measures that were introduced and those liabilities that have accrued over the past year become now unpayable, and they have to be met out of existing cash flows or new money is injected into the business. And typically what that does, a director will go out to a creditor and say, hey, look, I can't exactly pay you what's been deferred. Can I go on a payment plan? And especially with the ATO. But what the directors have to also realise is that these payments, the ones that need to be made up, also need to be made on top of the incurring liabilities that they're accruing. So there's a huge amount of stress that's been placed on directors. And what we've seen, some people have come forward and asked for help, and they've done it early enough to appropriately entertain a restructure, and whether that might be through the SBR regime or the voluntary administration process. But a lot of the directors, they've seen the increased equity in their properties. The house prices have gone through the roof, and they've gone and doubled down essentially without getting an expert involved to really assess the business. They've gone and doubled down and borrowed against their property to pay down creditors, but they haven't, I guess, rectified the underlying issues in the business. So they haven't, they might have some onerous contracts which need to be sorted through, whether it be property leases or they might be working with unfavourable supply terms. So there are all these things which need to be considered, and why sooner rather than later, directors should be talking to their advisors or restructuring experts to get them through to the other side. And that might be through the small business regime, or it might be through the voluntary administration process.
So I think the statistics, Ian, and Sam might have these handy, but I think there's been about, ASIC has got there's been about 14 proposals put together, but only 4, I think, have actually been approved by creditors so far. It's early days, and I know in terms of numbers that doesn't sound a lot, but as you say, the economy has been pumped up by government support at the moment. They're printing, a lot of funds being injected. It's early days yet, but do you think that this is something that, in terms of some of the impediments of people coming forward, that it's more likely to bring them out earlier to talk to, say, people like you and get some of that restructuring advice before it's too late?
I'd hope so. I just think it also goes to your point earlier around the narrative of the economy right now. It really has turned around quite impressively. So again, it goes to the director thinking, well, maybe I can get through this, so I won't need to come forward when they still have these issues. And it also, I was looking at the eligibility requirements, and to a lot of directors that come through our doors, some of them, they can't meet that criteria. They obviously meet the $1 million creditor amounts given the size of their business, but the director eligibility, making sure that all their tax lodgements have been made, so your GST, your pay as you go, and so on, all been lodged. And then you've got the additional, when they have to make their declaration, they need to make their declaration in the sense that they haven't entered into any voidable transactions during the past period. So obviously excluding preference payments. So there's a high bar there for directors to, albeit they may want to go and do this, but they just don't meet the eligibility criteria. But if people are educated enough, and and one of the things that we in dealing with our clients and especially our accountants, the accountants that deal with the SMEs out there, the accountants aren't necessarily clued up to these provisions, to the new regime. So it really becomes an education piece to tell the accountants, our clients out there, that there is this possibility, that there is a way forward. So yeah, it's really, again, get that message out there and the education piece.
Yeah, I like my personal view, it's early days yet, and people are probably still on the sugar high from bouncing back better than what everyone was thinking about. But I think once the message gets out there, hopefully, they will see this as an opportunity to come forward. One of the aspects of it, as we talked about, is finance. And Andrew, I was just interested in your thoughts on that, and how crucial you think and how difficult it is to implement some kind of finance restructuring or finance proposal to help see a company through a restructuring process, such as the one that's been implemented.
Yeah, thanks, Norm. So look, I mean, my general thoughts on this new regime is that it's a good opportunity for small businesses. I think it's a powerful opportunity to rehabilitate businesses and avoid liquidation. I think directors, will have to move early and quickly, and when they're developing that plan, they need to make sure that it's not an overly complicated plan. The more complicated it is, the harder it is for counterparties and creditors to understand and ultimately agree to. It's going to be important that there's a free flow of information to the restructuring practitioner as well, because they're ultimately going to have to sign off on that. And in relation to these putting forward a simple plan, as you rightly say, Norman, that will include making sure there is sufficient liquidity and finance in the business post the restructure and during the plan stage for it to be able to survive and thrive. I mean, in the SME space, with if there is a business in financial difficulty, then it can be notoriously difficult sometimes to get new finance. In many times, directors will be, relying on, friends and family for finance. Anecdotally, we're hearing that, with the increase in property prices, directors are, potentially being able to sort of refinance, against a family home to inject new liquidity. But that's risky as well, because you're most likely taking out personal guarantees there, so the bank can enforce on that. I guess one of the issues is that yes, it's a good start in Australia in terms of debtor in possession model, but in the US, for example, in terms of rescue finance, it's a bit more advanced, where new rescue finance, new money coming into a restructure, can often get a super priority over existing secured creditors, if certain thresholds are met. That's not the case in Australia, unfortunately. And I think, for a true rescue turnaround culture to be implemented in this country, then I think, eventually there will need to be some sort of, that super priority for rescue finance. And interestingly, I think, one of the potential advantages of going through the voluntary administration regime as opposed to this small business restructuring process is that a voluntary administrator can obtain new finance during the VA. Although there's not a super priority, it does get priority as an expense of the administration, which is above the priority afforded to unsecured creditors. But you're right, it's very important to be able to secure that post restructure finance, and unfortunately in the SME space, that can be difficult.
Right. So in relation to the financing, Andrew and Ian, I mean, obviously these provisions, the new provisions, are sort of modelled on some other jurisdictions, and I think America, Chapter 11, has been in place and has debtor in possession provisions for quite some time. And the market there, from what I understand, in terms of financing companies in trouble, is a lot more sophisticated. It's sort of understood that obviously it's important that when a company's in trouble, that in terms of helping it trade through the issues, that they're able to meet the payroll commitments and any other cost in terms of stabilising it through the restructuring stage and restoring some supplier and customer confidence. It seems to me that whether or not it's enforced by the courts or specifically prescribed by the new provisions, there's always an opportunity, and I've seen it in some of the deals that I've worked on, to bring finance in there. And as long as you can show benefit to the creditors in terms of the ultimate result. And it seems to me that, the types of businesses that probably at this stage and under this regime or a voluntary regime have a greater prospect of securing debt under those arrangements is where the secured creditors might be heavily based on the cash flow of the business and therefore rely on making sure that an important value component of their security survives I'd be interested to hear your experience in terms of what you've found recent times, or just generally in terms of trying to, without a formal regime, to protect, debtor in control finance, to negotiate arrangements for financier that wants to actually come in and finance through that stage. I mean, you mentioned, Andrew, the voluntary administration is sort of an informal way of getting priority. In the absence of that, have you found a willingness for creditors to participate, or a certain scenario more favourable than others?
Yeah, it's a good question, Norman. So I think in probably the last sort of 5 to 10 years, there's becoming in Australia a pretty well developed second, third tier lending market. So if there are companies that are in distress and they're having difficulty financing current loans, then there is a pretty active second, third tier market. Now, if you are accessing that tier of the market, then you're paying a much higher interest rate. And again, they're generally going to be wanting security, against the family home and personal guarantees. And I think that's why it's important for directors to act early and get advice early, because the sooner you can put in a very clear plan, once you've got that narrative and you can model that out in cash flows, three-way models, then you can go to financiers, you can, your current lender in particular, you can get, give them comfort, you can rebuild that trust, show that, you've got competent advisors in place, rebuild that trust and work out a plan with your current lender, often which is the big four banks, where you've got a much lower interest rate, and rebuild on that relationship. So look, I think in summary, you want to redevelop that relationship and trust with your current lender. But if that's not possible, then there is an active second, third tier lending market for assistance in times of distress.
Ian, do you want to add anything to that?
No, look, I think Andrew's covered most of it. I think it's, you're going to your point about earlier, Norman, about relationships, and it's quite important, especially when you might be in certain industries where creditors are very active and, very aggressive in how they deal with their customers and so on. So, it's very important to develop on those relationships. And when, and as Andrew spoke about dealing with the banks, and especially the big four, if you are in there early enough and you're taking them along with the journey, they're likely to be more supportive and look at potentially resetting a lot of those covenants that have become a bit onerous. So, there's good opportunity there. We've seen it, a number of matters, especially given the banks and their attitude towards enforcement. They don't like to do that anymore. So they are quite supportive of the process.
So the slide that's up at the moment has got a number of barriers, I suppose, faced by financially distressed companies. The removal of management, the stigma, the formalities, and the costs. And there's been a lot of criticism that the regime, at least in Australia, has been heavily focused on supposedly giving returns to creditors, and there's not enough balance to sort of say, look, to get over the stigma of someone who's set up a business, given it a go, and then finds that they found themselves in some tough times, to not be seen as some kind of dishonest or criminal person who's taken money and run away. And I think one of the intentions of this scheme, and I think what's happening in the international arena, is to redress that balance and to try and get a better balance between the debtor interest and the creditor interest. How do you feel that these new provisions help to redress that balance? Do you think that they adequately redress it, or do you see any major holes that you think still needs to be looked at?
I think given the level of creditors, so that 1 million creditor amount, that for eligibility, if you look at it, in most businesses, your ATO is going to be your largest creditor. So if you're, you look at it, before you got to have all your lodgements up to date, your tax returns and everything else all put up. You may not have paid those. So when it comes into entering into these, the small business restructuring, the ATO is likely to be the largest creditor. So they will have the ultimate say, I would think, and they're guided very much by public policy. So, in the past 12 months, they've been very lenient towards businesses and very supportive of businesses getting through this process. So I think this does, in a way, with the ATO being there, I think this does give power back to the business, especially where you've got employees and the continuation of employment. That's high on the priority of the ATO right now to make sure that nothing, you're not sending a business into liquidation just for the sake of it. So I think it does address some of those issues that have been raised.
Do you think there's still quite a bit of stigma attached? And that's one of the reasons why people don't come forward?
Yeah, absolutely. I think there's still that issue around that stigma involved. I think you really only hear about in publications about the big, the virgins falling over and a big bunch of board of directors. I think you don't really hear about the mum and dad or the SMEs falling over so much. They only tend to make the papers when they've done something wrong and breach directors' duties and so on, and liquidators are chasing them. So I think that's right. I think that stigma is still there. Hopefully, the SBR does remove some of that, but again, it probably goes towards why we haven't seen a real uptick in this type of work, just because of those barriers and obviously stigma being one of them.
So Andrew,
I might just add to that as well, Norman.
Yeah.
So I think when you're talking about stigma, I think you also need to talk about where sort of the power resides in these distress scenarios, and then and again that feeds into as well around whether Australia really does have a turnaround culture or not. So I think that even with this process, the power still does reside in these scenarios with the major banks, the big four banks, the secured creditors. So unless we get that true turnaround culture where there is that super priority and the secured creditors actually can be stopped from enforcing their security, then I think the power will reside with those secured creditors. I think the stigma will remain, and that true turnaround culture in this country, I don't think can really grab hold and get that strong sort of foothold.
So under the regulations, the court actually has a lot of power, and I might sort of get Sam to talk generally about the feeling. I know that one of the things that we discussed is the view about power of an independent body to oversee these processes and to make sure that you don't have like outliers or rogue creditors that really disrupt the ability of the plan to be implemented successfully. And the regulations actually state that that the court may order a secured creditor of the company not to realise or otherwise deal with the security interest except as permitted by the order. Now that's subsection 2, full stop. So there's a lot of power there, potentially. But obviously the ability of the court to exercise that power, and again, it's early days, may evolve over time. But in doing so, it has to be satisfied that the creditor For the creditor to realise or otherwise deal with the security interest would have a material adverse effect. It has to take that into account, and it also has to have regard to the terms of the plan, the terms of the order, and any other relevant matter, and that the creditor's interest will be adequately protected if the order is made. Now, just reading that, it seems to me that there's quite a bit of scope. I might just ask Sam quickly for a comment on that, and maybe some of her knowledge of the powers of overseeing bodies in other jurisdictions, and if she wants to make a comment about that regulation.
Thanks, Norman. I do agree on your reading of the regulation that the court does have the power to make any order, and that could extend to providing or authorising the debtor to secure additional financing, which would in effect be a form of debtor in possession financing. So there is that avenue, and that may later down the track give rise to an increase in a market for debtor in possession financing. I don't disagree with that at all. I suppose the main difference between the courts in Australia under the SBR and the courts overseas in other jurisdictions is the courts play much more of an oversight role. So they still provide control to the debtor and simply are involved to the extent that they tick off, they check the box, they ensure that there is transparency in the process, ensure that the plan meets the criteria under the law, that the creditors have approved the plan, and where necessary, they can also authorise debtor in possession financing. I think that's the main difference. Overseas, there is that oversight by a judicial body, whereas we don't really have that in Australia. The courts aren't as involved or managing the process, and there isn't the administrative bodies that oversee the Corporations Act and the Bankruptcy Act, AFSA and ASIC, aren't really involved in that oversight role either. It's left up to the RP to determine whether the debtor meets the criteria and then submit the form, and up to the creditors to confirm, to vote on the plan and approve the plan, and the RP basically gives the tick and then submits that to ASIC. So I think that's the major difference between the courts in Australia under this process and the courts overseas under the jurisdictions, under the restructuring processes in other jurisdictions.
Thanks, Sam. So it seems to me that one of the major impediments is to get the balance right between the interests of the debtor and the creditors. And as we stated earlier, part of this is to encourage people to have a go in business and to not see it as a failure in itself, but just as an experience to move on and get back. And the earlier people are encouraged to come forward when they're having issues and to put together a plan which takes the interests of its customers, its creditors, its staff, and its owners into account, the better. And as we said, there's been a number of impediments supposedly in the past, people doing that and doing that early enough. I'm just interested, before we conclude today, just to get people's feel on whether or not, in their opinion, there's a poll question there, in your opinion, there should be a more even balance between the interests of the debtor and the creditors in a restructuring process. Because I think to the extent that there is, then I think that a major impediment, and if you look at those practical considerations, the cost, the cumbersome, the formalities, the complexity, not utilising the knowledge of the people that have run the business in the past, and the stigma is really affecting the ability to turn around businesses, or even people to have have a go and fail and see that as an opportunity to learn and move on and do it again. So I might take the poll now. I'll just ask my technical people to do that for me, and if people can vote, it'd be interesting to see what happens. And before we get the results of that poll, what I might ask for Ian and Andrew, just in conclusion, to say whether or not they agree that, to an extent, whether it's intended or not, these are early days yet. We've talked about why the take-up may not have been significant so far. But it seems to me that if people understand the process and feel comfortable with the process, and as Ian said, are educated in the process, and it starts to develop and pick up, that subject to some further fine-tuning, it may be actually expanded beyond what's considered small business. Just be interested, Ian and Andrew, for your thoughts on that possibility.
Yeah, thanks, Norm. So, at the moment, you've got that $1 million threshold. So I think it's a bit of a feel and wait and see approach at the moment from government. And if there is a take up and it's being used ethically and competently, and it isn't being abused, then I think there is a lot of scope to increase that threshold, and to make it more available, and to try to really develop that turnaround and rescue culture and the entrepreneurial spirit in this country. But again, I think the key things is it's done ethically and competently.
Thanks.
And I might just add just quickly, Norman, it's safe harbour. When that was first introduced, that was also quite slow. And I was really wondering when it was first introduced whether anyone was going to take it up at all. But safe harbour obviously is probably geared towards large entities. As really, there have been a number of appointments that have come out of the safe harbour regime. So it might be again just the understanding and knowing that this is actually here. This regime for small businesses is actually here, and gain momentum like it has with the safe harbour regime.
Yeah, well, I hope so. Actually, quite interesting. The poll question, whether or not a more even balance would be appropriate. The poll results are in, and it's unanimous. 100% of the people polled on our poll there believe that a more even balance would be better. And that's quite interesting, because I as a finance lawyer, and been involved on both sides of receiverships and insolvency, the law, I think, quite clearly is focused on creditors' returns, and particularly secured creditors' returns. And so to see a shift, at least in the audience, as acknowledged by the audience in legislation that tries to put a bit more balance between the interests of the debtor and the creditors, could be a positive step, and over time it could expand. Sam, is there anything you would like to add before we conclude? Samantha? Might have lost Samantha. But anyway, there we go. Because I know that's an important thing in our discussions and your experience that you find in other jurisdictions.
Absolutely. I think that balance is really important, and the debtor-focused approach is vital for a successful business restructure, and for the reasons that are shown on the screen. The main one being that the nature of the debt, business debt, is that it's often commingled between business debt and also the personal debt of the directors, it's often related to personal guarantees provided by the directors over assets such as the family home. So there is a big incentive, if the director knows that they can remain in control of the business and the asset, and has the support of their creditors to undertake this process. I think that's vital. And yes, the balancing of the interests of the creditor and the debtor are very important.
Thanks, Anne. Now, if anyone has any questions, this is your last opportunity to ask them. But if not, I'm conscious we've now taken up your hour. So on behalf of everyone, I'd like to thank you for attending today's webinar. Once you leave the webinar, you'll receive a short survey on today's presentation, and we would appreciate your feedback. You'll also receive a follow-up email in 24 hours with a link to view the recording of today's webinar and the slides. So if nothing else, I'd like to thank, Sam, Ian and Andrew for their contribution today. And I hope that today's been a first step in helping, or a step in helping educate our audience on the new provisions, so that really what I think we all agree on, the panelists we've discussed before, is the biggest problem is to make sure that if you're running a business and you're having problems, you don't bury your head in the sand, and that you seek professional advice and support as quickly as possible before your options close. So on that note, I'd just like to thank everyone and look forward to the next webinar that we're able to share with you. So have a good day and thanks for joining us today.
Thank you.
Thank you.